Hi, I'm Mark Nelson. I'm one of the writer analysts in the Federal Solutions Group here at Wolters Kluwer Law Business. This video is an extension of a webinar that I co-conducted with my colleague and principal analyst Jim Hamilton a couple of days ago. Some of you may have joined us on the call, in fact. In this video, I'm going to limit myself, however, just to talking about the upcoming Supreme Court term and three cases in particular that the court has already agreed to hear. Two of these cases get at Securities Act Section 11, but in slightly different ways. The third case, if there is a little bit of a human interest or an emotional tug in securities law ever, the case of Yates versus the United States may be that one. But let me go back here and start with PERS Mississippi versus IndyMac. This is a case where the court has agreed to hear the question of, and I'll quote here from the petition for certiorari, does the filing of a putative class action serve under the American Pipe Rule to satisfy the 3-year time limitation in Section 13 of the Securities Act with respect to the claims of putative class members? We have a number of themes that may arise as the court considers this case. One is whether American Pipe applies at all. The second is what effect the Federal Rules of Civil Procedure, the relation back doctrine, in fact, may have in this case, and whether Section 13 is even a limitations period or whether the 3-year period at issue here is in fact a statute of repose. The district court in this case dismissed a bunch of consolidated complaints, including claims under Section 11 of the Securities Act. The Second Circuit affirmed, essentially saying that American Pipe tolling did not apply here, and that Federal Rules of Civil Procedure also did not apply here, the relation back doctrine, because the separate claims were not timely filed. I think what the court will do here, in addition to kind of reviewing its decision in American Pipe and Crown, Cork, and Seal, which extended the American Pipe tolling doctrine a little bit, I think the court will probably zero in on its earlier decision in the Lamp case from 1991. In that case, involving the judicially created a private cause of action under Exchange Act Section 10b and Rule 10b-5, the court looked to the express provisions of the securities laws for determining what the applicable statute of limitations should be. And in deciding that case, it actually intimated that Section 13 in the Securities Act may in fact be a statute of repose, and tolling would be inappropriate under that provision. I think in this case, it could be that the Supreme Court's decision will be just as stark as what the Second Circuit said in affirming dismissal of the case here in IndyMac, and that would be that if it's a kind of equitable tolling that we're looking at, then the Lamp decision applies, and the case is over. But the same result may also obtain if we look at this as a kind of legal tolling, and that really does depend on the court's interpretation. But if it is kind of a legal right under the Federal Rules of Civil Procedure, especially Rule 23, then that may actually expand a substantive right which would violate the Rules Enabling Act. We'll have to await the court's decision in this one, but of course a very important one as well. The next case up is Omnicare Inc. versus the Laborers District Council. This case, as I said before, it's one of these cases that gets at Section 11 of the Securities Act, although this one does so much more directly than the IndyMac case does. Here the question really centers on whether, for purposes of Section 11 claims, may a plaintiff plead that a statement of opinion was untrue merely by alleging that the opinion itself was objectively wrong, or must the plaintiff also allege that the statement was subjectively false? In other words, do we need to look at the speaker's subjective mindset? Here in this case, the plaintiffs claim that some company executives for a nursing home and healthcare company had made some statements of opinion that were wrong about the company's compliance with government regulations, and then brought suit against the company under the securities laws. The Sixth Circuit ultimately, in this case, decided that objectively wrong would be good enough. Obviously, Omnicare is happy to point out to the Supreme Court that this is a departure from the subjective falsity required in some other circuits, including the Second, Third, and Ninth Circuits. Already we've seen some amicus briefs filed in this case by SIFMA and by the Center for Audit Quality, essentially urging the court not to interpret Section 11 here in a way that would produce runaway liability for auditors or underwriters in helping with securities offerings. This case, much like IndyMac, which is looking back at the Lamp decision and some other earlier Supreme Court decisions, I think this case here involving Omnicare also will look back at the Supreme Court's earlier Virginia bank shares case. That was a case in which bank directors, even though state law probably didn't require them to, nevertheless solicited proxy statements in advance of a shareholder vote to approve a merger. What got the executives potentially in trouble there, at least according to the plaintiffs in that case, was their supposed statement of opinion that the minority shareholders were going to get a high share price in a merger and that would be a fair price for them. The plaintiffs in that case said, the executive statements merely the director's statements merely belied their intention of remaining on the board after the merger, and they had to say that essentially to get the merger approved and keep their seats. The case came to the federal courts really as two separate cases. In one case, there was a jury verdict in favor of one of the minority shareholders. In the other case, which had been kind of bumped around from one federal district court to another, ultimately applied the doctrine of collateral estoppel, and the court granted summary judgment in favor of the second minority shareholder as well. The Fourth Circuit upheld both judgments, and the Supreme Court took the case. Ultimately, what's relevant here for the Omnicare case is what Virginia bank shares really had to say about the actionability of statements of belief. Here, in Omnicare, the Sixth Circuit said that Section 11 is a strict liability statute. There's no scienter requirement, so the speaker's subjective mindset is not really at issue. This, as I said before, contrasts with some other federal circuit courts that have said that they apply Virginia bank shares to require subjective falsity in these cases. The subjective falsity requirement really comes from one key sentence in the Supreme Court's Virginia bank shares decision. And I'll take a brief look at my notes here to read exactly what the court said. The court said that a statement of belief would be actionable, and I quote here, solely as a misstatement of the psychological fact of the speaker's belief in what he says. There are a couple of ways that Virginia bank shares could be interpreted. Because there was a jury verdict here where the court seemed to think it was obvious that the jury assumed, at least, that the speakers in Virginia bank shares did not subjectively believe what they said was true. The court also said that they would have to show that the plaintiffs there would have to show that the speakers were also objectively wrong in what they said. But the notion of the subjective belief requirement really comes out of that and how one interprets the specific facts of the Virginia bank shares case and what the court had to say about those facts. It's also significant here, I think, to note that in a footnote in the Virginia bank shares decision, the Supreme Court expressly said that they were going to continue reserving the question of whether scienter applied, in that case, to the proxy provisions in Exchange Act Section 14A. The last case I want to talk about today is the one that I said maybe has a little bit of a human interest to it, maybe a bit of an emotional tug, and that's Yates versus United States. Already a number of amici have come in on Mr. Yates' side saying his prosecution and conviction for violating the Sarbanes-Oxley Act anti-shredding provision was really a prosecutorial overreach. The question here really is, was Mr. Yates deprived of fair notice that destruction of fish, in this case red grouper fish, could violate the anti-shredding provision that Sarbanes-Oxley added to the federal criminal laws in order to prevent future Enron-like frauds. Just by way of background, Mr. Yates was a Florida fisherman. He was stopped out at sea in the Gulf of Mexico by Florida Fish and Wildlife agents When he returned to port, those same agents checked his catch again and noticed that some of the fish were missing, and ultimately he was, as I said, charged, prosecuted, and convicted of violating the SOX anti-shredding provision. I think something to watch for in this case are some of these overarching themes like federalization of criminal law, federalization of securities law, and also principles of federalism, just kind of separating out the separate worlds of the separate worlds for federal regulation and for state regulation, especially in the criminal law setting. Here we have a case actually from last term called Bond versus U.S., which may serve as a roadmap for the court in the Yates case. In the Bond case, the court, in an opinion authored by Chief Justice Roberts, held that a purely local act under a domestic law implementing a chemical weapons convention was not the kind of thing envisioned by Congress as something that should fall within the purview of the federal criminal laws. In the Bond case, Bond was a woman who was accused of injuring her romantic rival with a caustic agent that, as the court said, caused a minor burn that was easily treated. In that case, what the court said about the Chemical Weapons Convention and the law implementing it was that the term chemical weapon really was intended to refer to very dangerous chemicals that could be used on a wider scale than was the case in Bond. I think if the court here kind of uses this case as a roadmap, it might look to some of the canons of statutory construction in reviewing the Sarbanes-Oxley provision. For example, they might decide that this really isn't the purview of the anti-shredding provision, or what Mr. Yates was accused of doing with destroying fish, because the anti-shredding provision may have really been intended by Congress to apply to things with information or record-keeping purposes in mind. And so this would be kind of an overreach of the federal laws to prosecute that. But again, like all roadmaps, they aren't always necessarily up to date or perfectly accurate. And Bond, of course, is not necessarily a perfect analog for the Yates case, but it is one very important recent decision that may inform the court's decision as it considers the Sarbanes-Oxley Act's anti-shredding provision. And that brings me to the close here. As you can see, we have three very interesting and cases before the court this term. There's always a possibility we could get another one or two before the term gets started. I might point out that the IndyMac case has already been set for oral argument on Monday, October 6th of this year. So stay tuned. We'll have more updates in the Federal Securities Law Reporter and again in our daily news service, Securities Regulation Daily, about these and other securities law cases throughout the year. For now, I'm Mark Nelson, Wolters Kluwer Law and Business.